Hello, this is Gwen Aspen with Operation Landlord, and in this video we're going to discuss the Fair Credit Reporting Act of 1970 and how it affects you as a landlord. The idea behind the Fair Credit Reporting Act is that consumers have the right to know about the information contained in their credit reports, especially when that information results in negative action against them. This full disclosure allows consumers the opportunity to change the information if it is at all inaccurate or erroneous. So this makes sense, right? So how does this affect you as a landlord? Well, if the information contained in someone's background or credit report causes you to take an adverse action against them, then you need to disclose this fact. What is an adverse action? It could be rejection of housing, requiring a cosigner on a lease, a deposit that wouldn't be required for another tenant, or increasing the rent to a higher amount than what you would require of another applicant. So if you take any of these actions against a tenant due to any information in their credit report, even if it's not the primary reason you took that action, then you need to disclose that fact in a formal letter. The letter must state the information in their consumer report is what resulted in this action. And you must give the contact information for the company that provided you with the report. So this needs to include their name, address, and telephone number. And you also must state that the agency did not make the decision to take the adverse action, and they cannot give a specific reason for the adverse reaction. Also, you need to state that the tenant has the right to dispute the accuracy or completeness of the information provided in the report, and that they have a right to a free credit report from that agency upon request within 60 days. For more information, check out this website. So even if you tell the customer over the phone this information, it's always a good idea to supply it in a letter just to make it official and to ensure that there's no misunderstanding. What happens if you do not comply with the Fair Credit Reporting Act? Well, the law allows individuals to sue landlords for damages in federal court. A person who successfully sues is entitled to recover court costs and reasonable legal fees. The law also allows individuals to seek punitive damages for deliberate violation of the Fair Credit Reporting Act. In addition, the Federal Trade Commission, other federal agencies, and the state may sue landlords for non-compliance and get civil penalties. Because of these consequences, it's very important to comply. So this concludes our short video on the Fair Credit Reporting Act. This video is not comprehensive in nature, and we are in no way legal experts. So it's important that you research the law further and speak to a lawyer about your personal situation. This video is produced by Operation Landlord. Please see other informational videos at our website, www.operationlandlord.com.